Good evening, everyone. My name is Jeff Green. I'm the director of the Andrea Mitchell Center. I want to welcome you here to our event this evening. Certainly from an American perspective, a lot has happened since we last met in December. And I think much of the recent events has pointed to the relevance of the topic of our faculty workshop series that's convening this evening, free speech battles. Whether long-standing questions, such as the bounds of permissible protest and the matter of when speech is rightly punished for promoting violence, or more recent questions, such as the propriety of large tech companies impacting speech by providing or denying online platforms. We are appreciative of all who have participated in the series last semester and look forward, beginning today with our guest Neeti Nair, to 5 more events to conclude the series this semester. The Mitchell Center is grateful for the co-sponsorship of Penn's South Asia Center for today's event. And I also want to thank the planning committee that is responsible for organizing all of the free speech battle events, both from the fall semester and the newly begun spring semester. And this includes Sigal Ben-Porath from the Graduate School of Education, who's the chair of the planning committee and has led us so ably throughout. It includes as well Joseph Lowry from Near Eastern Languages and Civilizations, Sophie Rosenfeld from History, Amy Sepinwall from Wharton, Takufu Zuberi from Sociology, and Matt Roth from the Mitchell Center. I should also add that today's event marks a first for the Mitchell Center. It's the first ever podcast event before a live audience. It will be moderated by Matt Berkman, who has been the center's most frequent podcast interviewer, having hosted 24 of the center's 30 podcast interviews conducted to date. All of these podcasts, by the way, are available on the Mitchell Center website, where you'll find a wide diversity of topics and themes examined. We're grateful for Matt Berkman's leading role in the podcast initiative. And just to give you a brief introduction to him, he received his PhD in political science from Penn in 2018 and is now a visiting professor at Oberlin College in Jewish Studies. Among his many accomplishments, Matt's dissertation, entitled Coercive Consensus, Jewish Federations, Ethnic Representation, and the Roots of American Pro-Israel Politics, recently won the Walter Dean Burnham Dissertation Prize from the American Political Science Association. Now I'll turn things over to you, Matt. Oops, I think you're still muted.
Unmute myself. Hello. Thank you so much, Jeff, for that introduction. Everybody, welcome to the podcast of the Andrea Mitchell Center for the Study of Democracy at the University of Pennsylvania. As Jeff said, I'm Matt Berkman, and our guest today is Neeti Nair, Associate Professor of History at the University of Virginia, and the author of Changing Homelands, Hindu Politics and the Partition of India. She's currently working on a comparative legal and political history of hurt sentiments in India, Pakistan, and Bangladesh. Nair has held fellowships from the American Council of Learned Societies, the National Endowment for the Humanities, the American Institute of Indian Studies, and the Harry Frank Guggenheim and the Andrew Mellon Foundation. It's a lot of fellowships. She is also a global fellow at the Woodrow Wilson International Center for Scholars in Washington, D.C. Welcome to the podcast, Neeti, Professor Nair. Are you there, Professor Nair? There you are. Hello. Welcome to the podcast.
Thank you. Thank you for that kind introduction, and thank you to the Andrea Mitchell Center for this very kind invitation to share my research, and I look forward to your questions and to this conversation.
Thank you for being here. In your new book project, you're looking at India, Pakistan, and Bangladesh, and you're telling a story about the development of law, policy, and political discourse around this idea of hurt sentiments. So I'm wondering if first, can you tell us, can you just explain the phrase hurt sentiments, tell us its origins and the different ways that it's been deployed over time?
Sure. So the phrase hurt sentiments has become a way to quickly reference legal cases that are filed allegedly because the litigants' sentiments are hurt by a publication or a speech, a film, or a cartoon even. The idea that Indians were especially predisposed to having their sentiments hurt or wounded is first elaborated upon by law member in the East India Company, T.B. Macaulay, in his draft note on the Indian Penal Code in 1837, almost 2 centuries ago. Macaulay held that there was, and I quote, "no country in which the government has so much to apprehend from religious excitement among the people." In framing the chapter of the Penal Code on offences relating to religion and caste, he argued that the British wished, and I quote, "to allow all fair latitude to religious discussion, and at the same time to prevent the professors of any religion from offering, under the pretext of such discussion, intentional insults to what is held sacred by others. We do not conceive that any person can be justified in wounding with deliberate intention the religious feelings of his neighbors by words, gesture, or exhibitions." However, he went on to record exceptions, such as, and I quote, "a warm expression dropped in the heat of controversy, or an argument urged by a person in good faith for the purpose of vindicating his own, will not fall under the definition contained in this clause." We find the same argument being made throughout the colonial period about Indians' propensity towards getting their religious sentiments hurt, and we see a similar caveat for exceptional situations, such as when a person, let's say an academic, might make an argument in good faith during debates to amend the Indian Penal Code a century later in 1927. In the post-colonial period, that is after India and Pakistan became independent in 1947, debates on whether a book or a film, a politician's speech, or a stand-up comedian's performance have hurt sentiments have breached the domain of the courts. What we now see in all the three countries that continue to use Macaulay's Penal Code in amended form is increasing recourse to extrajudicial authority to claim justice, or rather vengeance, for these hurt sentiments. Let me give you one example that will interest those involved in free speech on campuses. An academic essay on the Ramayana, written by the renowned philologist and poet A.K. Ramanujan, titled 300 Ramayanas, 5 Examples, and 3 Thoughts on Translation, that a litigant, Dinanath Batra, argued hurt Hindu sentiments, was ultimately removed from a graduate history syllabus in Delhi University in 2011, not because of any judicial ruling, although the matter did go to the courts, but because the vice chancellor of that university, its president in effect, was persuaded to do so by a right-wing student political party that represented the same cause as the litigant. So it wasn't expert academic opinion on the quality of the essay or judicial opinion that decided the case, but a combination of the brute street power of a right-wing student party and more than a streak of authoritarianism on the part of the vice-chancellor. Emboldened by this easy victory, the same litigant went on to demand the banning of more books and succeeded each time in cases that were often resolved outside the courts. So hurt sentiments, once sought to be contained within the four corners of the Indian Penal Code, is now primarily adjudicated outside the courts. I should add that the 2017 Law Commission of India report on hate speech uses the phrase hurt sentiments to argue for new legislation that will prevent a new class of injury amounting to more than, quote, hurt sentiments, but to less than harm in the sense of physical injury, close quote.
Thank you. In the book project, the parts of it that I've read, you're writing about the assassination of Gandhi in 1948, and also about, more specifically, about the trial, the execution, and then the subsequent rehabilitation of his assassin, Nathuram Godse. I'm not sure if I'm pronouncing that right. I hope I am. Could you tell us that story about Godse as it relates to this overall argument of your book about hurt sentiments?
Sure. When I began to study Gandhi's assassination, I was aware that his assassin Nathuram Godse's defense statement had been censored and banned from publication within India. I hadn't read it myself, and so I was interested to learn why it was censored. It was finally published in English in 1977 when a non-Congress party formed the government. Today, it is widely circulated on all sorts of websites with ponderous voiceovers reading the text and juxtaposed with images from the trial. Godse's statement at the Gandhi murder trial is a textbook example of what constitutes Hindu hurt sentiments. His defense statement is reflective of the time of partition, a time when many Hindus believed that the Congress had indulged in what they called Muslim appeasement and carved out a territory called Pakistan out of what these Hindus called undivided India or Akhand Bharat. He invoked the past as a series of blunders and argued for a Hindu theocratic state in the guise of secularism. He also used a fair bit of what we would today call fake news and misinformation. Now, what is erased from from Godse's defense statement is the extent to which the organizations to which he owed allegiance, that is the Hindu Mahasabha and the Rashtriya Swayamsevak Sangh, the RSS, themselves perpetuated the idea of Hindu supremacy and two nations. As I explain in my first book, Changing Homelands, Hindu Politics and the Partition of India, it was ideologues of Hindu supremacy such as Bhai Parmanand, who wrote in 1929 in a book called The Hindu National Movement that, quote, the Hindus and the Muslims differ from each other in every respect, and that the idea of a common nationality is for the present impracticable in India. This was published 11 years before the would-be founder of Pakistan, M.A. Jinnah, made a similar claim that Muslims and Hindus constituted two distinct nations. So it was a bit rich now in his partition writings and in his trial in 1948 for Nathuram Godse to lay the blame for partition on Gandhi and the Congress party and thereby seek to justify his assassination of the Mahatma. The work done by hurt sentiments in Godse's defense trial is, I believe, fundamental to understanding contemporary concerns over Muslim appeasement that are floated by Hindu supremacists in India today. It is the same Hindu hurt, for instance, that was invoked during the years-long assault on the 16th century Babri Masjid in Ayodhya, leading to its destruction in December 1992. Understanding the roots of this Hindu hurt takes us back to the fundamental fault line running through post-colonial India, the great divide between Godse and Gandhi. I explore this alongside the gradual appropriation of Gandhi by the Hindu right and its consequences for the development of Indian secularism.
Well, that's a great opportunity for me to ask you about this concept of secularism, which features so prominently in your new project. How have South Asian interpretations of secularism changed over time? And what have been the consequences for speech and religious expression of those changes?
Thank you. So I realized as I proceeded with my research that it was impossible to study these instances of hurt sentiments without situating them in the prevailing state ideologies of the day. I also found that outside the Constituent Assembly, the term secularism had gained quite a bit of popularity, so much so that even the newly repurposed Hindu Mahasabha, unbanned 6 months after Gandhi's assassination, declared that it stood for a secular state in India. The only difference is that the Hindu Mahasabha argued that Hinduism was inherently secular and tolerant. It was other religions that needed to learn tolerance from Hinduism, so on and so forth. As far as India is concerned, secularism has never meant the separation of church and state. When deployed by members of the Congress party or academics who have written about the ideology, it has typically meant equal distance from all religions, or as some scholars have suggested, equal intimacy towards all religions. In my research into parliamentary debates at the time that a constitutional amendment was introduced to insert the word secular into the preamble to the Indian Constitution, I found that by the mid-1970s, secular had come to encompass an aspiration across different classes, castes, and regions. But it was also widely recognized that secularism had suffered in implementation and that there remained a wide gap between the rhetoric of Indian secularism and its practice. So parliamentarians of all political parties, while swearing by secularism, also wished to see plans and policies put in place to ensure that religious minorities would be better represented in educational institutions, in appointments in the high courts, in public and private sector enterprises, in government. In short, they were asking for affirmative action or reservation to be introduced for Muslims as well as for scheduled castes and scheduled tribes who had converted out of Hinduism. And I find that all these demands were eventually negatived by Indira Gandhi's party during these debates, which is during the emergency when she not only had a majority from an election held 5 years ago, but she had also by then arrested much of the opposition and clamped down on civil liberties. Now, as far as censorship in India is concerned, if you look at case law alone from the 1950s through the 1980s, there is no progressive tightening of censorship. However, other arms of the state and other ministries, such as the Home Ministry, begin to get interested in the nitty-gritty details of censorship. So I came across this effort in the Home Ministry to set up a book censor board that would censor books coming from overseas and thereby stop their import by way of the often used Sea Customs Act, that is to say, without public debate. Now, the difficulty lay in constituting a book censor board. So in Britain, for instance, both E.M. Forster and T.S. Eliot rejected being part of such a board, raising the valid question, quote, how should we trust the person who chooses a board to choose the right people? End of quote. So because the decisions to accept the charge of hurt sentiments, whether taken by a book censor board or the vice chancellor of a university, were taken outside the courts, I don't think it is useful to restrict oneself to case law while studying cases of hurt sentiments. If it is street power that is enforcing its diktat, it becomes necessary to see how that is dealt with politically. So this is a political history about the management and regulation, and in some instances, rechanneling of hurt sentiment into something that can potentially get more votes. Then the question to ask is, how do the guardians of Indian secularism respond in such a situation? And the verdict is clear, even more so in retrospect, right? They do so pathetically. Let me quote an expression that I came across that was used by numerous sympathetic contemporary commentators in the 1990s, and I quote, secularism cannot operate in a vacuum, end of quote. But why was this vacuum allowed to develop by the 1990s? Why wasn't more done to give substance to the rhetoric and demand for secularism over the course of so many decades? A study of the way cases alleging hurt sentiments have grown exponentially in recent years can also help us grapple with the limits of secularism as containment or management of religion. The state ideology of Indian secularism today is a byword for Hindu majoritarianism.
Before I move on to the next question, I just wanted to let the audience know that we're going to be taking Q&A after I'm done asking my set of questions, and you can ask a question through the Q&A function. Don't put them into the chat, but put them into the separate Q&A function that you can see at the bottom of your screen. Okay, so Professor Nair, your story begins with Indian independence, but it goes all the way up to the 2019 Citizenship Amendment Act, India's Citizenship Amendment Act. So let's talk about this contemporary context. What did the 2019 Citizenship Amendment Act do? What kind of change does it represent from the past? And how does that controversy relate to the concept of hurt sentiments?
Okay, so first, I realize you have another event coming up on the Citizenship Amendment Act next week at the Mitchell Center. So I will very briefly say that the Citizenship Amendment Act of 2019 makes it easier for Hindus, Buddhists, Sikhs, Christians, Parsis, Jains in the three countries of Pakistan, Bangladesh, and Afghanistan to get Indian citizenship. They have to provide some sort of proof that they have been persecuted as minorities in these countries, but we don't have details of what this proof will have to look like. Now, the biggest objection to the act is that by excluding Muslims on the grounds that they are not minorities in these countries and therefore not worthy of being considered as persecuted, this is an open question. This raises other questions which we can come to later. What the act does is it opens the way for Indian Muslims to be targeted and accused of being illegal immigrants. The reason is that the documentation that is required to prove Indian citizenship is onerous. And we know this because of a recent exercise called the NRC, the National Register of Citizens, that was carried out in the northeastern Indian state of Assam. The paperwork required to prove that every Assamese resident was a citizen was so draconian that many were unable to do so, and their paperwork was dismissed for reasons as minor as a typo in some cases. Eventually, almost 2 million names were omitted from the dreaded NRC list, and the fear is that these doubtful cases are going to end up in detention centers for the rest of their lives, and these detention centers are actually being constructed across India. Now, if this exercise of determining citizenship is allowed to be carried out throughout India, it will amount to legislatively sanctioned persecution of India's Muslims, since those found to be lacking proper documentation will be labeled illegal immigrants from Bangladesh or spies from Pakistan and be put into detention centers. The Indian judicial system being as slow as it is, they will end up staying there for the rest of their lives. And we know this from the experience of so many Muslims, especially from Kashmir, who have spent years as under trials in prison. So at its core, the movement of people resisting the Citizenship Amendment Act, the question is, it's a question of amending the Citizenship Act so as to make it easier for people of a particular religious community to get Indian citizenship. So at its core, it's a question of who has the right to belong to India on terms of equal citizenship, a fundamental right enshrined in the Constitution. Now, according to the Home Minister, Amit Shah, the act is about undoing the wrongs committed by the Liaquat-Nehru Pact of March 1950, a pact that was forged to provide security to minority communities in the wake of the horrific violence that characterized India's partition. Now, this reference to the Liaquat-Nehru Pact was part of Amit Shah's speech and rationale in Parliament on December 9th, 2019, hours before the act was passed. This is why I see the CAA as aiming to fundamentally transform the character of India to make it a Hindu Rashtra, a Hindu state for Hindus in the main. So the charges of hurt Hindu sentiments that have repeatedly been flung at Muslims, for instance, in the build-up to the movement to build a temple to the Hindu god Ram in the late 1980s, early 1990s, are also trying to achieve the same goal, that is, to build a Hindu Rashtra. What is the secular response to the repeated charges that today's Muslims are responsible for causing Hindus hurt and trauma for the destruction of temples that may or may not have happened hundreds of years ago? Whether you define secularism as equal respect, equal distance, or equal intimacy towards all religions, or the state's regulation of religion, it has to stand for something when minorities are threatened. And that has been its greatest failing. What we have instead seen is that the judiciary and almost the entire political leadership has been towing the lines dictated by the Hindu right. But I see hope in the commitment to secularism that drove the anti-CAA protesters. And this to me suggests that it might make sense now to make a distinction between state secularism, which is increasingly absent, and everyday or popular secularism, which might be on the ascendant.
So it seems from what you've written, and you've talked mostly about India now, but in what I've read, you're looking at India, Pakistan, and Bangladesh, and it seems that you're identifying a similar pattern in each state in which, all three states have gradually abandoned some level previous level of minority protections in favor of more majoritarian and exclusionary laws and policies. So my question for you is, what explains this pattern that we see across all three states?
Yeah, so I examined some of the debates about protection for religious minorities in India and Pakistan in their founding years, and later in Bangladesh, because after all, the partition was supposed to have resolved the problem of India's religious minorities. As we can now see so clearly, it did nothing of the sort. So my study of these debates suggests that there were crucial design flaws in the constitutions of all three countries. What is interesting to me is how these flaws, the lack of sufficient safeguards for minorities, were the subject of intense debate, especially in Pakistan, where the Bengali Hindu and Punjabi Christian religious minorities were extremely vocal about their uneasiness in a self-professedly Islamic state that also saw its own creation as the product of not wanting to be a minority in undivided India. So Pakistan's founders took particular care to at least verbally address and assuage the concerns of their new religious minorities. In my reading of the debates around and following the Objective Resolution of 1949, these concerns were addressed, which is why these very vocal minorities decided to give their new nation state a real chance and decided to stay in Pakistan. Now, what has happened in subsequent decades, especially after the War of 1971, is that Pakistan decided to double down on its Islamic credentials to curry favor with the Arab world, especially after the oil crisis of 1973. And as noted by anthropologist Asad Ali Ahmed, General Zia's additions to what are called the Blasphemy Laws were an attempt to shore up state authority in the face of social and religious agitation. In the case of Bangladesh, there was too little time for the war-torn country to even try and implement secular principles, always defined as being not against religion, but for harmony between all religions and against the misuse of religion in politics. Barely 2.5 years separated the ratification of the new Bangladesh constitution and the assassination of Bangladesh's almost entire political leadership. The Premier Mujib Rahman's successors were the military generals Zia-ur-Rahman and H.M. Ershad, and they both moved to bring Islam and Islam-based political parties back into the mainstream in order to shore up their authority. Safeguarding the rights of religious minorities under these circumstances was not a priority. In the case of India, I think we need to revisit the founding years to look more carefully at the role of the Hindu right in influencing and shaping the drafting of the constitution, much of which might not be available in the recorded minutes and proceedings of the Constituent Assembly. So we have to look at other sources, not just the debates in the Constituent Assembly.
So this is my last question, and I want to let everybody know that they should submit their questions now if you have one, because we're going to move on to Q&A right after this question. Okay, so my final question is, you addressed this at the beginning, but I thought maybe you have more to say about it, because it's a point that we hear a lot about the way that former colonial regimes impacted legal structures of post-colonial states. So my question is, can you say more about to what extent the legacy of British colonialism features in the story that you're telling here?
Yeah, so, it's been more than 70 years since the British transferred power and India and Pakistan won their independence. And I have in an article on the history of Section 295A of the Indian Penal Code, colloquially referred to as the Blasphemy Law, that was adopted in 1927, almost a century ago. I have argued that the law was a product of the collective endeavors of Indian legislators and the British, so it isn't strictly accurate to call it a mere colonial law, although it was certainly a product of politics in colonial India. Now, although it is possible to draw a line that connects the obsession with litigation around hurt sentiments today with Macaulay's concern not to wound the religious sensibilities of Indians 2 centuries ago, I think it would be disingenuous to do so. The work done by hurt sentiments today is of a profoundly different order than in the colonial period. Indeed, myriad calls to reform India's criminal laws have recognized this, and the same is true for the case of Pakistan, where the Zia era laws, there's a real call to reform these. And I think it's also instructive to learn from Britain's own experience of her blasphemy law. It took multiple attempts over the course of 2 decades for the House of Lords and the House of Commons to finally abolish the laws of blasphemy and blasphemous libel in 2008. And this is despite the fact that the law had last been used in 1977. At the same time, it took multiple attempts to amend the Public Order Act of 1986 that bans incitement to racial hatred, so as to make it include the offense of stirring up religious hatred. All of this is to say that colonial legacies notwithstanding, I see the increasing use of these laws and the will to reform these laws as a product of more recent politics. Thank you.
Wonderful. Thank you so much, Neeti. We're going to do some Q&A. We've gotten a number of questions. I'm going to try to start with the ones that require less explanation, because some of them get pretty specific and in the weeds of Indian politics, but maybe we can come back to some of those and ask you also to kind of explain the terms that people need to understand. So the first question I'm going to ask is, okay. Hurt sentiments, someone asks, for religion are often conflated with ideas of defamation of religion. These ideas of defamation have also been deployed by other mass organizations, including state organs and corporations. Is it possible to disentangle the anti-secular character of hurt sentiments, of the hurt sentiments crowd, rather, from the broader anti-speech from motivations in India? That's what the question is. Does it require clarification, or can you say something to that?
I'm trying to find the question.
The question.
Has it disappeared? There it is.
You see it. Okay.
Right. If you're saying, so the question, to the extent that these allegations of something hurting sentiments is being deployed to say that you're also defaming a Hindu god, I think it's impossible to disentangle it from the presumed secular ethos of the Indian state. But I think there is a recognition for a new category called hate speech. So there isn't actually a category called hate speech in the way the laws are ordered today. So if we were to try and look for which laws would qualify, we'd have to look for laws from very many different chapters of the Indian Penal Code. But the 2017 Law Commission report that was produced makes a case for, in fact, adding further laws that make it a criminal offense to damage, hurt sentiments, cause insult, cause offense, but not physical harm. And I think, a response to that would be to say that there are enough laws already in the law books that can be used for exactly that kind of situation. So the last thing we need, in a sense, are more laws. What we need is to make the scope of these laws narrower. I think the category of hurt sentiments today is so broad that it includes the casual, everything from the casual allegation that this particular, let's say, comedian has caused offense, to something much more serious, like Nathuram Godse's allegation that Mahatma Gandhi has hurt his Hindu sentiments by acquiescing in or agreeing to the partition of the Indian subcontinent. So at the moment, yeah, that's what I would say. I think I'll leave it at that.
We have a couple questions that touch on the issue of transnational connections, one broad, one more specific. I'm going to read them both, and maybe you can reply to the general idea or any of the specifics. The first one is, could you talk a bit about how your historical research on hurt sentiments in India might be useful in thinking about current forms of political contestation in other parts of the world today? So that's the broad question. The more specific version, or more specific question is, thank you for this talk. I'm wondering about the transnational reach of the politics of hurt sentiments, which extends beyond South Asia. The glee with which Quran burnings were carried out some years ago in the US and Europe seemed to suggest that hurting sentiments is a fully legible idea in the West too. Despite protestations of defending free speech, these performances were calculated to cause hurt. I'm wondering then whether there is a global dynamic to this politics too, and how it might relate to the story of South Asia that you tell. Great questions.
Excellent questions. Thank you for both. Let me, I think if I answer the second question, I'll probably end up answering the first as well. So, the person who's really written about this at some length is Talal Asad in his essay responding to, the kind of responses that Salman Rushdie's book, The Satanic Verses, received its reception in Britain and the responses afterwards. And I think there are real parallels to the protests that erupted through the 1990s and, to the response to these cartoons in 2005, 2006. And you're right, of course, that hurting sentiments is not something that is restricted to South Asia. And it's in response to, what some see as hate crimes, hate speech that does violence, that there was a movement in Britain to have the Religious Hatred Act put into the law books, and that eventually transpired in 2006. I think the story of South Asia is different because these debates take on a very different balance. They are able to determine in some measure almost the formation of governments or the nature of governments. And I'm thinking of, the Tehreek-e-Labbaik in Pakistan and its sudden rise since 2017 and 2018, and how well it's been doing even in electoral politics. Now, if you look at the situation in the United States too, I think we're at a particular moment where there's recognition that hate speech can do real violence, even to the citadel of government. And I think this might be a good time for me to refer to a book that was edited by my colleagues, Charlottesville 2017, my colleagues Claudrina Harold and Louis Nelson. And this has contributions from professors at UVA Law School, including Frederick Scheer, who is, the historian of the First Amendment in the United States. And a lot of these historians from UVA Law School are arguing that it might be time to think more creatively about the limitations of the First Amendment and of US exceptionalism. So I think we're at a very interesting moment. I suppose if you had asked me this question in December, I would have said that, the politics around hurt sentiments and hate speech has a particular valence in South Asia. Now I'm beginning to think it has a particular valence even in the United States. I think I should.
Next question is, you referred to other sources outside of the Constituent Assembly debates that can illustrate the impact of Hindu nationalists on the Constitution. Could you tell us about those sources and briefly summarize your findings about them?
Yeah, so I have looked at oral history transcripts in the Nehru Memorial Library of key actors, key political actors who played a role in the Constituent Assembly debates in the 1940s. And I've looked very closely at newspaper debates. So that meant sitting in the rare books section of the Library of Congress and going through very old issues of The Organizer, which advertised itself as the #1 leading English language magazine in India. It was a magazine, weekly magazine produced by the Rashtriya Swayamsevak Sangh, and I found that some of its issues were available in microform in Delhi and many weren't. So I think I was the last person who had access to the hard copy of this journal. It was falling apart and the librarian said she was going to give it for it to be made into digitized or put into microfilm rolls. So I think if you juxtapose contemporary newspaper accounts along with some of the reminiscences of political actors who attest to the kind of debate that was happening outside the Constituent Assembly, but was affecting the proceedings of the Constituent Assembly. I think these are really, it raises a lot of very interesting issues. And I think rather than think of the Hindu right as being one of 4 or 5 key influences, as other scholars have done, I would give it a lot more prominence.
Here's a question. To what extent is the contemporary right-wing discourse of Hindu hurt sentiments different from, first, Godse's defense, and 2, the kind of Pakistani legislative banning of Ahmedes from being recognized as Muslims? So yeah, how does the contemporary right-wing discourse of hurt sentiments differ from those 2 things? Is the question.
So let me say that the contemporary right-wing discourse of Hindu hurt sentiments reminds me a lot of Godse's defense. The phrase that is often used is that of Muslim appeasement. It has the same elements of what I would call misinformation and also erasure. So erasing the role of the Hindu right in escalating tensions, both in the 1940s and of course, in recent decades. So I find that there is a huge overlap. In the case of Pakistan's banning of the Ahmedes, there were different stages to this, right? So in 1974, you have the Second Amendment. A decade later, you have actual teeth being given to this kind of legislation. And then you have, legislation being put together. And then you have the hounding of Ahmedis so that they have to practically seek asylum abroad. Now, one of the things that I find common in both India and Pakistan today is the rise of procedural irregularities. In other words, of mobs taking the law into their own hands. So you have, whether it's bombs being thrown into Ahmadi homes, individual assassinations of Ahmadis, or whether it is the lynching of the ordinary Muslim who might be carrying buffalo meat. You have people on the street motivated by a certain, this kind of rhetoric is becoming more acceptable. There's a sense in which you can get away with it too, right? So you can target a religious minority and nothing's going to happen to you. You might actually end up being chosen to be a member of a political party, or you might become hailed as a hero. So this is why I find that looking at this issue from, just from a legal perspective, from what happens inside the courtroom, is really insufficient, because the magnitude of the problem is now so enormous that it's spilled outside. It's beyond the courtrooms. It's practically anybody can target a minority, and there's so much impunity. They can get away with it. And that is true for the way Ahmedes are targeted in Pakistan, and that is true for the way a lot of Muslims are being targeted in, parts of India like Uttar Pradesh, etc.
Okay, we got two more kind of general or kind of ones that don't require you to have a specific knowledge of specific Indian laws, but I will throw in some of those other ones. I will try to get to them. But first, I'm going to ask, do you observe differences in what you call Hindu hurt sentiments within India and the subcontinent more generally, and what is seen in the Hindu diaspora in places like the US and the UK, locations that politicians kind of tap for funding?
That's a great question. And the truth is that I haven't done enough research on my own in the Hindu diaspora, but it's sort of been on my radar that, we're beginning to see instances of caste atrocities in the US getting media attention. And of course, this has been an issue in India, at least for the last 2 decades, an issue that has been getting media attention. But I haven't really studied this question. I think in the US, I would say there's a little bit of embarrassment to confront this question. There's much more comfort with the idea that India is a secular country, and a lot of discomfiture with engaging with the opposite, engaging with anything that can go against the soft power projected by India. So it's really a source of strength, and so there's very little willingness to accept that the reality, especially for a religious minority in India, is actually quite different.
Okay, so I'm going to put two of the specific ones together. I have no idea if they speak to one another. I hope they do. So what is the status of the National Register of Citizens? In your view, how might it be continued? And then the second question is, what is the outlook for a uniform civil code becoming law in India, as the BJP has called for, especially after they have successfully abrogated Article 370? So we would need you to tell the audience, those of us who don't know what the Uniform Civil Code signifies here and what Article 370 is, and also the National Register of Citizens. Thank you.
Right. So the National Register of Citizens was a project that was supposed to have been embarked upon in April 2020, but thanks to coronavirus, it had to be suspended. It's not clear when the government will go ahead with it. A lot of people, commentators, have commented on the fact that the rules for the CAA to be implemented have not been delineated and elaborated upon. And I think that might be because of the political calculation by the ruling party that they want state elections to finish in, let's say, West Bengal, which will be affected by this decision. I don't think they have been at all moved by the protests against the CAA, which were not allowed to run their course again because of coronavirus. It's really not clear whether the NRC will go ahead or when it will go ahead. I'm not in a position to answer those questions at all. Even for the Uniform Civil Code, so this has been an article in the Directive Principles of State Policy section of the Indian Constitution. So it's part of the Constitution to aspire towards having a uniform civil code, and it has been a particular item on the BJP's election manifesto. ever since the late 1980s. They have promised that they would like to work towards uniform civil code. It is to be uniform across religions. Again, it's Muslims especially who are uncomfortable with the idea of a uniform civil code because they see it as impinging on their personal laws, and they see it as another instance of Hindu majoritarianism under the guise of uniformity, that they will lose what is distinctive about their religion. So the original plan, I think, was to wait for a little bit of time after partition until Muslims became more assimilated in a way, or at least began to feel more at ease within India, and then to broach the idea of having a uniform civil code. But that's actually never happened. If you look at, Muslim parliamentarians, for instance, speaking in 1976, they were all very much in favor of having secular inserted into the preamble of the Constitution, but they are also speaking out for preserving their Muslim personal law and therefore against having a uniform civil code. And that anxiety to preserve their distinctive religious customs has continued into the present. So I think it's quite likely that the BJP will try to push this through because they have an absolute majority in parliament and because it speaks to their base. And it would really be in keeping with, the abrogation of Article 370 in Kashmir and such measures that they have pushed through since coming to power in 2019. So I wouldn't be surprised.
Could you speak a little about the explicit role played by institutions in South Asia such as the court systems or the media in being the guardians of the categories of hate speech versus hurt speech? How are these institutions allowing for hate speech to flow from powerful political actors while stifling progressive or creative speech as hurt speech?
You've answered the question in a sense, right? So powerful media houses can get away with hate speech every evening in their talk shows, and academic speech or academic writings, which are supposed to actually be protected under these laws, have not been protected. Or even if, in the case of the A.K. Ramanujan essay, to which I referred, even though the Delhi High Court said that this was outside their jurisdiction and that they dismissed the case and said this was something to be decided by the Academic Council of the university. And even though the Academic Council of the university, created yet another expert committee that in its majority said that the A.K. Ramanujan essay should stand, ultimately Delhi University chose to delete the essay, to take it out of the syllabus without consulting the historians who had put it on the syllabus. So this is something that has been going on actually since the early to mid 1990s, especially, where we find the expert opinion of historians, of professional historians, of academics being completely ignored. The power of the street mob taking over. In the case of James Lane's work on Shivaji, we note that this mob was allowed to vandalize manuscripts in Oriental Research Institute library in the city of Pune. So they destroyed hundreds of years old manuscripts in their so-called anger and righteous rage and hurt sentiments at the way that Professor Lane had portrayed Shivaji, all because he acknowledged the Bhandarkar Oriental Research Institute in the acknowledgements section of his book. So this is not new. It's sort of been going on now for the last 2-3 decades, and it doesn't leave much hope for academic writings on the subject sometimes, yeah.
How much of the threat of hurt sentiments is based on the threat of tying someone up in litigation and pre-conviction imprisonment rather than the actual specter of conviction under these laws?
I think that's a good question if you're considering the case of M.F. Hussain, the artist who had more than 1,000 cases slapped against him for allegedly painting Hindu goddesses in ways that were hurtful to Hindu sentiments. And so you had people filing cases against him across India. And it became such a nightmare for him that he moved to London and eventually died in exile in Qatar. So it's about delegitimizing people in India, but I think it's also sometimes it's also a question of getting a public apology and then, in many instances, using that to shore up one's own political status and maybe getting onto the radar of the BJP as a viable political candidate, maybe in the next municipal elections. So getting the attention of the RSS or the BJP, this has really been one route to getting the attention of people as you know, to say that, look, I'm able to gather a crowd of protesters and vandalize gallery, an art gallery, or prevent the screening of a film, or have the film producers edit these scenes out. So I think it's not just a question of tying someone up in litigation, but also of furthering your own political career in some cases.
Next question is, I'd be curious to hear more about the specific language of hurt sentiments and what you think makes it so powerful. And the questioner also asks, and maybe you've already touched on this, but if you want to say more, also, have you noticed similar kinds of discourses like hurt sentiments in US politics?
So it used to be said that secularism in India consisted of, utter disregard for religious sentiments, that the secularists were English-speaking, Oxford-educated elites who didn't understand religious sentiment or the regard with which people thought of, let's say, certain figures in the Ramayana. I think that's no longer the case. I think I think that would be a very hard case to make. I think that English-speaking secular elite has, in fact, doubled down on proving that it is deeply devout, deeply religious, and deeply committed, that they're all deeply committed Hindus, because there's a sense in which they understand that their so-called distance from Hinduism had proved to be an obstacle in their own political careers. I think there's something else that's also happening here. In the past, you had political leaders who were very, very devout in their private lives, inside their homes, but they didn't see any need to advertise their religious credentials to the media. But today what we find is a need for people to come out and say, politicians constantly saying that we're vegetarian, or we're Hindu, or we're opposed to the killing of animals for meat. And there's a lot of show and in promoting oneself as a viable politician for India because of what might be in one's refrigerator. And I think in a way, this politics is responding to the charge of secularists somehow being distant from the ordinary Hindu on the street. But I think what this has done, is in some ways so let me put it this way. in a lot of the case law in the 1950s and through the 1980s, you have references to the ordinary man on the street, right? To the reasonable man on the street. And the assumption is that we need to make our laws resonate with the ordinary man. So if the ordinary man is going to get hurt by this particular book, then it needs to be banned. The reasonable man. But of late, the projection of the reasonable man on the street seems to me to be most unreasonable. So they're taking the most insular, narrow-minded person and projecting that his sentiments are going to be hurt by what he sees on Netflix or by, but the truly powerful, as another questioner put it, are allowed to get away with blatant hate speech that might even incite a riot 2 days later. And we see this happening in 2020 in Delhi, and which is why I feel that, these cases, we really need to look at them outside the domains of the courtroom, because the powerful don't even get interrogated by the police, leave alone having a first information report filed against them. Yeah, I think I should stop there.
We have a question about how social media has affected this whole picture that you're describing. The fact that, for perhaps tech developments have changed, maybe they've changed older legal benchmarks, like the reasonable man on the street, when the streets are not the streets anymore, they're like the Twitter feeds or the WhatsApp or whatever, what have you. So how just in general has social media impacted the picture?
So I was speaking of how, Nathuram Godse's defense statement also has a lot of misinformation and rumors and fake news. And this is in the context of the violence of 1947. So he makes all kinds of accusations, even in his writings as a journalist and as an editor through the 1940s. And I would say that social media has only compounded that problem. And then you have the speed of social media as well. So in the case of India, we've had so many instances where a forward through WhatsApp has resulted in people being, 2 or 3 people being killed because they are seen to be child snatchers, or there are rumors that they are carrying a cow for slaughter in a region where cow slaughter is prohibited. And we see rumor untethered, unanchored, with no signature, growing at such a rapid speed that it becomes very difficult for the police to stop it. At the same time, we have also seen civil society groups, again in the city of Pune, in 2013, 2014, forming what are called social peace forces that decide to monitor Facebook and help the local police in monitoring hate messages on Facebook and alerting the police that there are these rumors spreading through Facebook or WhatsApp. And so we find civil society initiatives taking on the role of watchdogs, which could, of course, also so easily slip into acts of vigilantism. And I'm relying here on the work of the legal scholar Siddharth Narayan, who's written about this for the city of Pune in 2013-14. So there is a way in which the rapidity of transmission of rumors through social media can lead to acts of violence against religious minorities. And I should say that this is again not peculiar to India. We've seen this happen even against immigrants in Germany. I was teaching a course on free speech and blasphemy, and I found that the rapidity with which rumors spread that, let's say, a Muslim immigrant in Germany is responsible for having attacked someone, and then you have a riot. This happens in 2011 in Germany as well. So it's not an issue that is particular to India or just to South Asia anymore. And it speaks to a bigger problem with social media.
we have a question about the concept of secularism that you're dealing with, and the questioner asked that there's one dimension of debates about secularism that's not necessarily about how to treat religious minorities with equal respect, but it's a question about, are there some venues, for instance, parliaments, other formal state institutions, where religious speech should just not be permitted? And so the questioner wants to know, how has that dimension of secularism played out in the contestations around secularism that you're looking at, this idea of a neutral public sphere?
So there are certain occasions when it is actually illegal to canvass, let's say canvass electorally on religious lines. That's not allowed. But the problem is that it isn't enough to just have these laws about, Representation of People's Act in the books. In what we saw, for instance, in the build-up to the 2019 election campaign in India, was that even the Election Commission of India, which until now was seen as an institution that is really neutral and above the state, we found that even complaints filed with the Election Commission with video footage that clearly showed certain politicians stoking religious sentiments and canvassing votes along religious lines, those speeches were allowed to circulate. Or at most, the offending politician was barred from campaigning for 48 hours. So the really powerful have been allowed to get away with things that are perfectly, actually not allowed theoretically. So I don't think it's enough to have new laws to say that, we shouldn't have certain kinds of speech permitted in Parliament, because in a way we have versions of these laws already in place, but they've just been flouted, especially in 2014 and 2019 elections, and in recent years.
To what extent do you see the current political mobilization of the idea of hurt sentiments as a BJP problem? What I mean is, I hear many compelling reasons for pessimism in your research, but also maybe some perhaps ironic hope in the way that the BJP is currently rewarding the deployment of hurt sentiments in order to censor and censure. So do you think things would change if the BJP was not in power? Would it reduce the incentives to martial violence in the name of hurt sentiments?
Only if the non-BJP parties are willing to step away from that particular discourse. And I say this because, again, if you look at the historical record from the 1950s onwards, if you look at the kinds of books that were banned by even Jawaharlal Nehru and later by Indira Gandhi, there was actually very little appetite for books that they feared would cause a law and order problem. So books that I would, for instance, consider just brilliant and wonderful were just banned because they were seen as, in poor taste or not appealing to the ordinary man on the street. So I wish I could be more optimistic about, let's say, the Congress Party. The only reason for optimism would be if the Congress Party goes back and takes a clear look at what that has meant for the culture of debate in India today. And unless there's some learning from the past, I don't see too much hope for a non-BJP party to do better. Certainly, they have not done as badly as the BJP, but it's been a slippery slope.
And I guess it's a good question to conclude on. Our final question is, do you have thoughts on how to counter and critique the discourse of Hindu hurt sentiments? In other words, how do we resolve this problem?
So I think, we need to restore faith in the courts and the judicial system. And that partly means that the legal system has a lot to answer for. they need to step up and go by the law. It's because there's such little faith, I think, in the judicial system that people on the streets can act with such impunity. And I also think that we really do have enough laws. If anything, we need to make them less capacious, and we need to make them much tighter so that we can, so that when we talk of the four corners of the law, there are actually certain corners you can see, not that it is just endless and limitless and anyone can get within its ambit and get squeezed. I think sometimes I think that the ordinary man on the street, or the reasonable man doctrine, was much more used in a way that was much more secular and tolerant, even in the 2000s than it is now. So in just the last 2 decades, there has been such a huge deterioration. So yeah, I think we just need to learn some lessons, I suppose, from the past in order to be able to move forward.
Well, that's our last question. Professor Nair, thank you so much for being with us on the podcast and on the internet with all of our viewers.
Thank you. Thank you so much for having me over. Thank you.